Hi, I want to continue on our Module 5 with chapters 5 and 6 of the book. The first lecture had to do with the other independent reading, the law review articles. So let's look at chapter 5 of our book on why the law is so perverse. Chapter 5 starts our section, which is section 2, part 2 of the book, which is entitled, Why is Law So Full of Loopholes? And so this is our second main topic within the book. And chapter 5 is entitled The Irresistible Wrong Answer. So it starts by talking about a cartoonist, and his name is Reuben Bowling. And he then looks at some various things that this character named Harvey Richard, a lawyer for children, encounters, like some different things in the law that make you stop and think about it. So the problem that we're starting the chapter with is little Susie. She's in line for a movie, a very long line, and she asks one of her friends if she can go in front of her. And her friend's response is, I'll only let you go behind me. The friend is not going to give up their position in the line. You can only go behind me. But when this happens, the person that is already behind the friend says, no, they're not agreeing to that. And so Richard explains to Susie that she runs into the frontsies are fine, but backsies are not doctrine. And that's what he is telling her. So he gives her a solution to this, a loophole to this. He says, well, ask your friend for frontsies and then promise her that you will then give her a frontsies in front of you. So that if you go in front of her and then allow her to go in front of you, then you in fact have not done backsies. Immediately asked to go in back of her, which places you in front of the person behind. So it's a loophole. And the rule that this cartoon character, Harvard Richard, says is double frontsies are a solution to the no backsies rule. And you'll find on page 72 of the book the actual cartoon that is referenced here. And so our book, is asking the question, that what is strange is that given the contempt that we have for loophole exploitation, it is nevertheless central to legal practice. So he intends to answer 3 questions about loopholes in this section of the book. Number 1, first, why is the law so riddled with loopholes? Second question is, why, once detected, do they usually go uncorrected? Why are we not fixing loopholes? And then number 3, should lawyers be reluctant to exploit loopholes, or should they feel free to do so? So the author looks then at some typical loopholes and the seeming glitches in the formation of the law that allow clever lawyers to help their clients to subvert the purpose of the laws as written. So he starts in this chapter by giving us 3 examples. Number 1 is forum shopping. You'll find this on page 73 of the book. This is when, for instance, a married couple, they think the state they're residing in doesn't do their divorce quick enough, so they go through the motions of moving to another state temporarily. So that's a more hospitable forum for them. And so they're only going to stay there long enough to get a quick and easy divorce. And forum shopping is not prohibited but frowned upon in the law. It is a loophole. The second loophole that he is exploring in chapter 5 is asset protection. And so on 74, you'll find some examples he gives you where one tries to put their assets beyond the reach of actual or potential creditors, looking for loopholes such as deliberate self-impoverishment of the elderly so that the federal government can look after them. So that's another example of a loophole that exists, or a loophole that people try to exploit. Third example he gives is tax shelters, where you reassign someone's income, for instance, to their children because their child is in a lower tax bracket, or they give it as a gift so that it is not subject to taxation if it's below the gift limit. The next loophole area that he looks at is litigation proofing something. So a firm makes decisions, for instance, to destroy all documents for a fixed number of months that could potentially be incriminating because they know that their product might have an issue, so they get rid of their product testing before a lawsuit is ever brought. The loophole in this case is that the law forbids obstruction of justice, so once an action is filed, they are not able to do that, but because it predates a lawsuit happening, this destruction of property does not fit as obstruction of justice. The next example he gives is contrived defenses. This would be, for instance, a defendant who provokes his intended victim into attacking him so that he can claim self-defense, but essentially sets up the defendant for the scenario to justify his own murder of that person with a self-contrived self-defense, or creating an emergency situation, for instance, where he can cover up his crime under a defense of necessity or duress. Another example of loopholes, we're on page 76 of the book at this point, is political asylum by bootstrapping. The example he gives is somebody, a would-be immigrant to the United States, tries to bypass the usual waiting lines for an immigration visa by turning himself into a political refugee. So this person takes actions that would make it so that it is dangerous for him to return to his native country, and therefore he is then seeking to get political asylum and change his status while he is an immigrant. So the book looks at page 77, says, why are, the questions we asked at the beginning, why are there loopholes, given how much offense loopholes give, why are they not eradicated, and finally, what about the lawyers who exploit them or use them? Are they doing something dishonorable, unethical, or illegal? So the example he then moves into is an atypical loophole, which he defines on page 77 as the intentional foul as a legal phenomenon. So the example he gives, to give you the context for an intentional foul, is Shaquille O'Neal, who is an extremely formidable basketball player in every area except free throws. So he was deemed to be mediocre in that area. So his opponents would frequently go ahead and take the intentional foul to prevent him from scoring, because he was less likely to be able to do the free throws from the foul line. And so they would do this intentional foul, and this was done even though the offender fully expected to be punished, but it was a strategic use of this foul in order they would commit it anyway, because in an attempt to reduce the score, in other words, to gain an advantage. Also talks about this scenario where a doctor on page 78 does a transplant to the wrong patient and then makes the decision that he's going to then, because the person it should have gone to is going to die, in other words, resulting in a homicide, maybe a negligent homicide, he goes ahead and retransplant the organ because he now is guilty only of assault versus homicide. So even though what he's done is twice now made bad decisions, he actually improves his legal position by doing so. So we look on page 78 on what have courts done about loopholes and why has it not worked. And so there's three approaches that courts take when they're looking at loopholes. And so those are form versus substance approach, the intent to evade approach, and the spirit versus the letter approach. So we start looking at those on page 79, starting with the form versus substance approach. And in form, what is he getting is not income. So it's a company car, various ways where somebody's getting in-kind income versus monetary income. But the court is going to look at that and say, well, even though this is not actual money that this person is getting, it in substance is, because he's getting this car, he's getting this apartment, all his living expenses are paid. So you're looking at not the form of the payment, but the substance of it. So the court says, well, in this case, even though the form is not monetary income, in substance it is. So that's the form versus substance approach that a court can take when looking at things. The limitation to this is it only works in cases in which the legal actors are pretending to do something that other than what they're doing. So the court kind of is able to pull back the curtain and see what's really going on in the form versus substance approach. The second thing that courts do is the intent to evade approach. And so in this, a court will overrule all maneuvers that the defendant would not have engaged in but for the law whose effect he's trying to avoid. So if you're just doing something specifically for no purpose other than to evade, in the intent to evade approach, the court is going to nullify that as well. Third approach a court will take is the letter versus spirit approach, page 80. And this is when, this approach is when you're looking at whether a given stratagem subverts the spirit, purpose, or rationale of the law. And if it does, it gets struck down by the court. So when we're looking at the deeper logic here on loopholes, the book then points in the direction of the mismatch theory. This starts on page 80, and this is because there is unavoidable imperfection in all human creations, and so that when you're writing laws or where there's court decisions, they're all doomed to be over or under inclusive or with respect to their true rationale. In other words, the people writing laws, they have limited foresight on what is going to happen in the future, and also limited hindsight, what happened in the past that they're not able to look at completely either. Basically, because it's impossible for the rulemaker to anticipate all situations in which the rule might be applied in the future. And it might also be hard to determine when one is actually encountering them in practice. So loopholes both arise and persist because rulemakers are unavoidably limited in foresight and in hindsight. So I will give you examples of that, some examples of why loopholes happen. I was on a committee to write the parenting time order, the minimum parenting time order in the county where I served as a magistrate. And one of the issues we had is that a parent would have Friday at 6 to Sunday at 6 for their weekend, but then there might be a holiday that Monday. So that holiday might be 9 a.m. to 6 p.m. So what was happening in cases that were highly contentious is that parent B was getting Friday night to Sunday night and then was also getting the holiday on Monday, but parent A was making them return the child at 6 p.m. on Sunday and then keeping that child till 9 a.m. before that parent could continue. So we changed the local rule so that gap didn't happen. So that if you had the weekend, you would end the holiday, that would become also an overnight. That Sunday into Monday would be an overnight. But I'll tell you, as soon as that problem was addressed in the standard order of visitation in the county that I worked in, people who are highly contentious found other loopholes. So as soon as you closed one loophole because you saw that there was a problem going on, and you tried to make the language tighter in that area, there would be other language included in the standard order that someone else would creatively find a way around that while we were drafting, we weren't seeing, we weren't envisioning the way that they were going to apply that law. And that's the same thing that I also told you in a prior lecture, that I helped write the law that allows legal custodians in Ohio to adopt after parental abandonment, meaning de minimis support or de minimis contact with a child. But when I was drafting that law, I was looking at it in context of my husband and I, who both had legal custodianship of a sibling of our adopted children. So I did not envision the situation where one party would have the legal custody and then they would either subsequently have a spouse or they would have a spouse, but only one of them was named. And so what ended up happening is you would end up with two legal actions then, because the legal custodian would have to go back to the court that gave custody and get a new custody order that named them both as legal custodians before they could go pursue adoption under this abandonment statute. And it took about 10 years to get Ohio in their adoption modernization law that was just passed this March. Finally, I was able to get the amendment that says legal custodians and their spouses, grandparents and their spouses, and guardians and their spouses, which are all categories that are able to adopt after parental abandonment in the state of Ohio. So that's where the fallacy is, that when you're writing the law, when you're working with lawmakers, or when you're making the rule, it's sometimes difficult to foresee what somebody is going to do because you're looking at the situation that you have at hand. So it goes on in our book on page 83 that the root cause of the mismatch theory, and it basically calls this chapter the irresistible wrong answer. And it says rules really do tend to be over or under inclusive. I just gave you two examples on why that would happen. They either overshoot or undershoot the goal they were meant to reach. give you another classic example. In the state of Ohio, at one point, Ohio passed a law that said if you got 3 DUIs within a 5-year period, you had to go to prison. And the judge was not able to look at the independent circumstances to what was going on in the third offense or the person that was involved. And so what ended up happening is you had more egregious situations where people did jail time, in other words, a local jail for a year or less. And then people who were on this 3rd and 5 years, which might not be as egregious a situation, were automatically going to prison for longer periods of time because it took away the judge's discretion to look at the facts that were going on. So that's an instance where the law was overshooting because it was not allowing any discretion, nothing for the judge to look at the overall fact pattern, or the judge looking at the pre-sentence investigation for a defendant. None of that could come into play because the mandates in the law that it ordered that they shall go to prison, that they shall be imprisoned in that situation. And so that law later had to be amended to allow for some discretion. But when it was originally written, you ended up with some very unfair and not, the decisions were not meshing based on the facts that were going on because you eliminated judges' discretions. So I think it's easy to understand how limited foresight can result in loopholes, and that it's hard to guess in advance what can go wrong with a rule, where people are going to exploit it. So the author then wants to give you some examples of that and some other reasons that loopholes exist and how you're weighing in on that. So page 84, he talks about a friend. His friend's going to be convicted of a murder. He knows his friend, that's not consistent with his friend's character. And so if he perjures himself by inventing an alibi, then his friend will not be prosecuted. But then the person, the author, he uses I, so he uses the first person in the book, he can be prosecuted for perjury, and then he might plead the defense of necessity, that he exchanged a lie for a life. But this then, you have to look at the overall policy. Why do we have perjury in the first place? And so we adopt a general policy that whenever somebody reasonably thinks by perjuring himself that he will promote rather than hinder the cause of justice, he's entitled to do so. But this causes multiple other problems because you're asking judges and juries to be fact finders. You're asking them to find the truth, and the result will be we'll have less accurate fact finding and more erroneous verdicts and more erroneous acquittals and more erroneous convictions. So if we allow this defense of necessity, or in this case, that really perjury, the reason it's in place is so that our justice system can work effectively, so that our finders of facts can believe that when you're taking the stand that you are going to tell them the truth. Because if the opposite becomes true, that they can believe that in any given case somebody is not telling the truth because it benefits them or their friend or their family member, then we're undercutting our whole system of justice. So the larger difficulty here, he states on page 85, is stated by Larry Alexander, is there's always a possible gap between what we have reason to do, all things considered, and what we have reason to have our rules and the officials who are promoting and enforcing them require us to do. So we might think this perjury is justified, but there's a better reason in our society to have the rule that's in place and require us to do something else. So it concludes on page 86 on chapter 5 on number 1, why are there loopholes? And the reason is because there's always a gap between what we have reason to do and all things considered, what we have reason to have our rules and our officials who promulgate and enforce them require us to do. Number 2, why once detected do loopholes go uncorrected, and he gives an example there on why that occurs as well. And number 3, how under the circumstances should we feel about lawyerly exploitation of loopholes, and he states his position is it's probably appropriate for the same reasons that caused the loopholes in the first place, that there are situations, there are fact patterns that change our analysis and perhaps the strategy that we have to do. So he moves then into chapter 6, which is what is wrong with the irresistible answer. And so he states there are 4 basic problems with the mismatch theory, and that chapter 6 is going to talk to you about 3 of the 4, and he saves the 4th for a later chapter. So the first one that he gives on problems with the mismatch theory is evading God. So he talks about devout religious people, and they have commandments, and yet they will still find ways around them. So the mismatch theory, it cannot make sense of these religious ruses and what devout believers believe they are doing involves nothing less than taking advantage. What they are doing involves, the author's position is, involves nothing less than taking advantage of God's failure to give a sufficiently airtight statement of his commandments. Example, like a Jew hiring a Gentile to do things that need to be done on the Sabbath because the Jew is prohibited from doing that on their day of rest. But it's clear that the author states that the devout don't see themselves as doing that. They find the loopholes and don't actually believe they're circumventing God's rules. The next example he gives to the mismatch theory is evading tyranny, and this is subverting the ruler's orders by seemingly obeying them, but actually undermining the rules in subtle ways. And this, the author states, is one of the oldest forms of successful risk minimizing resistance. So the example he then gives is a situation where there's martial law, and then the people in the martial law state decide they don't want to watch the official government television news at a certain time, and so they start going for walks during that time with their hats backwards. So they're not overtly doing something, but they are basically peaceful demonstrating against the dictatorship. But the reason this evades the mismatch theory is that in a dictatorship, the dictatorship is not bound by the rule of law. So it's not that the command is insufficient because it's a dictatorship. The dictator is able to tell people what to do, and yet still that there are people who evade these tyrannies. His third counterexample is evading the guilty conscience. And so the author states, well, it's much easier for him to mislead than to lie. This is something I used to tell people when I was on the bench as a magistrate, that when people came into the court, that there's 2 ways that people lie: omission or commission. So commission is somebody takes the stand, that earlier example where the person lies and gives an alibi to their friend. That's commission. They make the decision to lie. They say something that they know is inaccurate. But equally probable when someone is taking the stand is lying through omission. So I'll give you the example of a 20-year marriage. There's no way in a 2 to 4 hour divorce hearing that the court is going to hear everything that happened during that 20-year marriage. So each party and their attorney is making the decision. What information are you giving to the court and what information are you not? So it's not necessarily always a loophole, but it's very conscious, the decision in any type of case you have, on what information you're bringing in through testimony and evidence, what evidence you're leaving out. And so through omission, you can mislead a court. You can present a different picture because you're giving the court this information, but you are not providing the court this information. And so what he talks about in this counterexample is that what he does makes it easier on his conscience. So then talks on page 90 about the consequentialist will hold views that we ought to generally do what will bring about the best consequences, whereas, that's the theory, the philosophy of life, that the ends do not justify the means. Conversely, there's non-consequentialists who say that the means matter greatly, not just the ends, and that we judge conduct both by the means and the ends attained. So looking at this question of lying through omission or commission and whether it's right or wrong, a loophole. So the author says that we're recognizing that something can't be done in one way, and yet we'll find another way, and our conscience is eased. This lying through omission versus commission, that we're not outright lying, so we justify what we're doing, and yet, again, it's a loophole. So it concludes this chapter, chapter 6, page 92, taking stock, says we've encountered 3 formidable counterexamples of the mismatch theory, 3 types of phenomenon outside the law that closely resemble loophole exploitation. And again, those were the 3 that we just talked about, which was evading God, evading tyranny and evading the guilty conscience. All right, I look forward to seeing you next week. Thank you.